Um, my, my pleasure now is to introduce as rapporteur of this conference William Binchy, BA, BCL, LLM, MA, FTCD, Barrister at Law. William is Regius Professor of Laws in Trinity College Dublin, formerly Special Legal Advisor on Family Reform to the Irish Department of Justice and Research Counsellor to the Law Reform Commission, member of the Irish Human Rights Commission, where he was an esteemed colleague of my wife. He has authored and co-authored books on private international law, torts and family law, and organises the annual workshop on constitutionalism for African Chief Justices and Senior Judiciary. That is held in the Trinity Law School and is now in its 10th year. He has represented Ireland at the Hague Conference on Private International Law on the themes of marriage and inter-country adoption. He is a member of the Committee on the Offences Against the State Act, chaired by Mr. Justice Anthony Hederman, and he has organised visits of the Tanzanian judiciary to Trinity College and also members of other judiciaries to Trinity, and also to remarkably successful interactions with the judiciaries in Ireland, and also visits by some members of the Irish judiciary to Tanzania. William Binchy needs no introduction to you. I now call on him to act as rapporteur and to wrap up.
Well, thank you very much, Judge. May I say it's been a long day for us all, I think it's fair to say. 6 speakers and then 3 members of that round table. So that's 9 people, quite a lot of speakers, as well as our esteemed chairman. And may I also say our wonderful organisers, Aisling has done such a wonderful job in organising this event, both before today and during today. And, of course, Gerard Quinn for his oversight throughout. So what I'm going to do is speak very briefly, just to remind you of what seems to me like an awfully long time ago this morning, just a few words of what the speaker said, and try to bring the thoughts, certainly that have been provoked in my head, together. And I think there may be some opportunity after that, after I disappear, for maybe some final words from the chair. Well, remember this morning we began really with Gerard, who opened the proceedings, and he said, if you recall, our starting premise is that law doesn't necessarily have the answers, and I think that's entirely true. I think anybody who feels that law has the answers rather than provides a vehicle for the answers, I think doesn't really understand what law does. Law is at its best really when it in some sense absorbs the normative, philosophical and political policy questions that need to be addressed. And my goodness, in this area, those questions are extremely difficult. It's just about easy to see what the issues are, but it's so very difficult to know what the solutions should be, what the best way forward should be. Our chair, when he opened proceedings, mentioned that the conference was designed to examine not just where we are at the moment, but where we're going. The same point, that this is a conference that's looking to the future rather than merely looking to the present situation. But we did have, in our first presentation, Professor Lowndes, who I think for many of us, certainly for me, and I think on his own acknowledgement, our chair, presented a very, very clear representation of the evolution of genetic science and technology in this area, and mentioned a number of facts, very stark facts, which were shocking facts, I think it's fair to say. That's what our chair mentioned. But equally, as he explained those remarks, he set the picture very clearly for us. And I'm not in any sense going to attempt to describe or summarise the science for you, may be glad to hear, but he did mention one statistic which is interesting, that it's likely that 1 in 4 children will have a disease consequence because of their identity. And he said we can't hold the tide back regarding patients' access to risk prediction. Our chair mentioned, as I say, surprise in this particular area, the shock of what he had heard, but Professor Lowndes described it as a wonderful shock. So he set as it were, the challenge to us to work out what the future policy should be in this area. Our second speaker was Professor Joly. He spoke on the theme, if you recall, of ethical and legal implications arising from use of genetic information by third parties. Covered a broad range of areas. Just focusing, this is not by any means the centre of what he said, but he did mention the question of what might be considered to be wrong or troublesome about genetic discrimination. And he mentioned that this challenges the ethical principles of autonomy, equality and dignity. And that's a theme to which other speakers returned and which I'll just say a word or two about perhaps as we proceed. We then had coffee. And after the coffee, we had the representation of the United States position, the GINA position. And it was wonderfully articulated by Professor Waterstone and then followed up on by Professor Adia. Professor Waterstone mentioned the long gestation of the legislation and how it had been, as it were, sidelined by political considerations which didn't affect it specifically. He mentioned also that it took 13 years, as I say, for it to come into full enactment. But he mentioned, which I think is interesting, that even after the legislation, only 16% of the population are aware of GINA. That's interesting that the impact was so slight in this area, and that health insurers are still asking for genetic information in this area. Mentioned the distinction between actions against insurers and employers, in the sense that you can sue an employer, but there's no private right of action against the insurer. Professor Adia mentioned a whole range of areas. One thing she mentioned was the thrill-seeking gene. I don't know that you'd be complimented or insulted to discover that you had a thrill-seeking gene. You might be both complimented and disturbed. Complimented that you have one, and disturbed that you didn't actually get the job on that particular basis, on the basis that your employers would not necessarily be too keen to hear that. She mentioned also that GINA, it's interesting, was a product of its time and has already perhaps been overtaken by technological advances. And that raises then the question that if one is going to have legislation in this area, one needs to be sure that it isn't so drafted as to tie itself down to the technology of the day. It has to be capable of adapting to changing technology and changing new social realities and relationships that follow from changing technology. A difficult thing to do, to have, as it were, predictive legislation rather than legislation capturing the moment. She mentioned also a case which was litigated, the Hubert and Howard County firefighter case, if you remember, where there was a 10% risk that the person concerned might develop a condition that would make him a dangerous employee in terms of health and safety issues. And she raised the question, well, is 10% right? What is the percentage here? How do we work out what a percentage risk is? It's not a question of mathematics, it's a question of norms and values and policies. And that, I suppose, again reiterates just how difficult it is to formulate policy in this area. After lunch, Judge McMiniman raised the question again, what values should underlie future policy? We're back to the value question. Obviously, we have to know the science, we have to know the technology, the social realities and the economic considerations, but at the end of the day, this is ultimately about values. Our fifth speaker was Dr. Roskam Abbing, and she spoke in the area of developments at Council of Europe level, Council of Europe norms on genetic discrimination. Set out the human rights position, both in terms of individual human rights and also social human rights. She mentioned a number of rights: right to private life, we'd expect that, right to physical and mental integrity, data protection, about which we heard more a little bit later, but she also mentioned the right not to know. And that's a right that is certainly worth examining, because I think that is at the core of this particular issue. The limits of legitimate knowledge, the limits of legitimate knowledge, the limits of your right to know and not to know, and the rights of others to know and not to know. And that's the core question, I think, at the end of the day. Can we actually, without being people who are against science, against technology, place limits on the knowability of certain information? Is it a question of privacy? Is it a question of inherent not going there? We might come back to that issue just in a couple of moments. Excuse me. She mentioned also about the European Union Charter, Article 25 of which refers to genetic traits and creates a horizontal entitlement. And Judge McMiniman picked her up on that particular matter of developing that, pointing out that in Ireland we do have a constitution based on horizontality of rights. It's a very, very radical notion, hasn't been fully developed by the courts yet, but it raises enormously interesting questions, from a legal but also constitutional nature in Ireland as to the horizontality of rights, the very simple notion that just individuals don't have rights enforceable against the state, but that we all have rights and responsibilities, reciprocal rights and responsibilities, the rights parts of which we can enforce against each other. I must not violate your constitutional rights, and you must not violate my constitutional rights. Bring that into the area of discourse which we have here, and that raises the question then of the relationship between employers and employees in terms of the respect for the rights of employees, and of course the relationship between insurers and insured. So our constitutional framework is already horizontal and carries therefore the responsibilities between individuals and non-state actors. Our sixth speaker was Dr. Ferry. She was speaking in the area of legislation and legislating at EU level, the possibilities and challenges. And as our chair said, she presented a very coherent and clear picture of a remarkably complex area of law. Just pick up one point perhaps that she mentioned in that area. She mentioned, well, 2 points maybe. She mentioned that the privacy approach could be adapted as well as the non-discrimination approach. And she also suggested, or at least raised the, not a dilemma exactly, but at least a policy question as to whether amending the existing directive is, the better way of going, politically easier, but is that sufficient? Or should one perhaps go for a new horizontal directive, which would, at least in theory and in principle, be the better approach, but maybe not so easy to attain? We then got to the round table, and we had 3 contributions, as you will recall there. Patrick Clark, first of all, speaking from the standpoint of President of Down Syndrome Ireland, and he raised the question about prenatal screening and prenatal discrimination based on disability. He referred to measures in New Zealand and Denmark which targeted the unborn in these circumstances, and he mentioned the question that issue has been studied by a Harvard team seeking to bring that before the International Criminal Court. Marian Harkin spoke of her experience in Europe at the European Parliament, and she raised a note which perhaps maybe we weren't quite expecting, which was that personalised medicine actually would require genetic information, and that it's not just all one-way traffic about restraints in this area. Perhaps there's another stream flowing in the other direction, which is necessary to take account of as well. And then our final speaker in the round table was Billy Hawkes, and he, in his very succinct way, presented a very clear picture of the Irish legislative framework here, referring to the basic protection of personal data, to Section 4 of the Disability Act 2005, which he said was parallel to or had similarities with GINA, and looking then to future developments, both at European level and perhaps at Irish level as well. A health information bill, possibly, and then the data protection law that is going to emerge from Europe, raising the question, is it going to be by regulation, in which case it would be directly applicable, or by directive, and raising also the possibility of a distinctive Irish contribution. So they are what, that's a kind of a 10-minute summary of what 6 hours of discussion and representation consisted of. I think it leaves me personally, and I suggest perhaps yourselves as well, in the position of tremendous feeling of having learnt a great deal. I remember there's a story told about a House of Lords judge who, having heard counsel's representation, said to Mr. Smith, this was F.E. Smith, he said, "Mr. Smith, I've heard you for several hours and I'm none the wiser." And Mr. Smith said, "Well, perhaps that is so, my lord, but you're certainly better informed," which is true. So we are all better informed, certainly, and we have the illusion, or I have the illusion anyway, a feeling of being wiser at the end of that very, very comprehensive day. Going forward, I know Gerard has good plans to develop this at a European level and at an international level, and this this centre that we are at today is such a wonderful place, and it is so vibrant and active. It really is a world player in this area, and good things are going to emerge. Only good things are going to emerge further from the place we are today. I suppose there are questions, and what the good judge said there in terms of, this is a values-based issue, but it's a values-based issue in a very real, human and practical way. I suppose the question is, nobody should be against science, nobody should be against technology, nobody should say no to scientific progress. But I suppose the argument would be is how best can that progress take place, on what principles should it take place? Because quite clearly scientific and technological progress has to take place in the context of value premises. So it's a question of identifying what those value premises should be and proceeding on that basis. A free-for-all without values, I think we would all agree, is not good science. It's bad science, actually, as well as being bad for human beings, bad for justice and bad for human rights. So the question really is, what is the working out the fundamental premises on which scientific research in this area should proceed, against a background of, realism and accepting the realities that, as I say, the strong desire to find out more, to know more, the inevitable progress of science, channeling that progress into sound principles which respect human rights of every human being. Thank you. I should pass the stage now.
Well, I should thank, I was assigned to thank William for a report, but what I should do on your behalf is to thank him for a tour de force. It was a remarkable summary. I am nearly finished my job now. I'll be calling on Gerard to close the conference. I want to thank William for having summarised in 10 minutes what we've listened to over 5 to 6 hours. Can I just tell one story, which is not entirely irrelevant? Just 5 or 6 weeks ago, I was watching a program on TV. It was about serial killers and psychopaths, and the guy who was doing the program carried out a study. He was trying to carry out an assessment as to whether there was a psychopathic gene, and he carried out quite a degree of research, and it appears tentatively that there may be some indications to that effect. But what was remarkable was that the guy who was interested in this and carried out the research also himself had this gene. And it raises the question, what does it mean to have the gene? And I don't want to sound like a lawyer in an American jury action, but it is an important question. What does it mean to have the gene? Because it may have a significance which is much less or much more, or may not be capable of being determined. I want to apologise for one thing. I omitted to go back to a question which was raised earlier, which Jean Bosco wanted to raise, and I'm sorry about that, because it very succinctly identified one of the dilemmas, where he was saying that deaf couples, when they are seeking to have in vitro fertilization, when that process of analysis of the sperm is taking place, if there is a gene which is a deaf gene, or part of the gene which is a deaf gene, it is deleted as being invalid. And that raises an interesting issue. And I don't think it requires anything more from me to say, and in some ways doesn't it crystallize some of the problems, some of the challenges that arise here. On your behalf, I want to thank Gerard and Aisling. We've all done that. It's been a wonderful day. And I do go back to what Thomas Jefferson said about laws and institutions must go hand in hand with the progress of the human mind. But what has been done today, I think, has been a wonderful contribution by the Centre in order to ensure that that process goes on. Thank you very much indeed. Now, Gerard Quinn.
Thanks very much. I'm only going to speak for 2 minutes, and thank you, John. I mean, I can never make up my mind whether I'm with John Adams or Thomas Jefferson. Probably a bit of both. I think you'll all agree it's been an incredibly rich day. There's been a lot of ideas, a lot of eyes opened, a lot of minds opened, and that's exactly, I suppose, the role of the Academy. In a way, it's been a very good vindication of the value of interdisciplinary research and interaction. And the sexy language now has a collision space between all these poles of ideas. But I think it's absolutely the right way to go, because law doesn't even begin to have the answers, although it is at the intersection of science and ethics, and it certainly comes into contact with the raw edge of human experience. So although it doesn't have the answers, it behoves us to work backwards and sidewards to engage very constructively with people in different disciplines. And I also think the day has been a very good vindication of the value of transatlantic exchanges. I don't mean by that to say that we should slavishly copy and paste each other on particular problems when one has done something before the other, but I think it's really, really interesting to see how the Americans have, in accordance with their own cultural genius and values, framed the issues, struck their own balances, and come up with some solution that may or may not stand the test of time. And its use to us is that at least it gives us some insight into the contours of the debate, and hopefully at the appropriate moment we'll craft our own appropriate European-level solutions. I want to thank all of the speakers. I mean, without exception, they really have all stepped up and contributed to progressively opening our minds to the issues. I think it was very interesting the way the alternative frames came through, either the privacy frame or the non-discrimination frame or even the property frame. And I was busily thinking to myself, is this a new species of intellectual property? And then I quickly drew myself back because, of course, you can't patent human life forms. But nevertheless, what kind of property is it to have a property right over this kind of information? I must say the scientific expose by Professor Lowndes this morning really blew my mind, because it's a really good example of how scientists do, contrary to popular misconception, have the ability to communicate very, very clearly and crisply to the population at large. And in so doing, I think you did a huge public service, and I would encourage more scientists to do likewise, because some of the social concerns about the science need to be allayed in order to allow the science to progress to everyone's advantage. I was also struck by Mira's concept of you can't unring the bell. Once the information is there, darn difficult to police a prohibition against discrimination, because even sometimes despite yourself, and you may even be tricking yourself, you are actually relying on the information to make decisions one way or the other. And the other thing that struck me is this notion that there's no such thing as anonymous data, that this data can actually be brought right back to the individual. I don't know where that leads me, but I was really struck by it. I want to thank the chair. Dean Roscoe Pound used to say that the task of the modern sociological jurist is to be, first of all, aware that the law always tends toward decay, and that's perfectly natural and normal in every legal system. But the task of the mature sociological jurist is to strive to bridge the gap between the law and the felt necessities of the time. So to me, you are the epitome of the Irish sociological jurisprudence, if I may say so. You did a brilliant job, and you held the day together beautifully. I also want to thank our rapporteur, Professor Binchy. It was once said of Oliver Wendell Holmes that he's the Yankee from Mount Olympus. So I think William is our Irishman on Mount Olympus. And when I say Mount Olympus, I don't mean Trinity College. I mean the Mount Olympus. Thank you, William. That was an absolutely brilliant wrap-up of all of the contributions. I want to thank the panel for bringing it home. And by home, I don't mean Ireland, I mean Europe, because to me that is our home. Pat Clark from the EDF, Marian Harkin from the European Parliament, who's been really, really good to us here in the centre. In fact, she made some very positive comments during the opening of our clinic by the Attorney General a few weeks ago. And we hope to take her up on our half offer toward the end of her presentation, that perhaps we might have a conference or a seminar or a hearing in some committee of the European Parliament, hopefully in the not too distant future, on this topic. And of course, Billy Hawkes, our Data Protection Commissioner, is extremely active both at the European level as well as at the Irish level. I want to thank everyone at the centre who's stepped forward. It's one of the privileges of working in the centre that we've very proactive students. There's nothing worse than learned passivity in PhDs, and thankfully I have none of those, and they're all so constructive and positive. It's just a great place to work. So I want to thank Meredith Rayleigh, Abigail Rekas, Charles O'Mahony, Roisin Fitzpatrick, Aileen Timmins, Eleanor Flynn, Conor Newman, but most particularly Aisling Dupuer, who's been really, really persistent. It's great to have a PhD who pushes back. That's exactly the way it should be. So thank you very much. And also want to thank our colleagues in the Burton Blatt Institute in Syracuse and Mira, who's here today representing them, who have partnered us on so many research projects in the past, and hopefully we might, maybe even with Noel, go forward for some European funding on transatlantic exchanges on these policy dementias. So I think you deserve a pint of beer, and safe travels wherever you're going, and thank you very much for coming. Thank you.